A district attorney's office can charge someone accused of domestic violence at the state level, but thousands of cases with allegations that aren't as serious are handled by city attorneys. When that happens, survivors aren't granted the same rights.
Someone that have been a victim of a domestic violence crime, they should be treated equally throughout the state. And sometimes that treatment is very differently depending on where your case lands.
Soledad Diaz is the public policy director of Violence Free Colorado. Her organization worked with state lawmakers last session to codify protections for victims in municipal court. House Bill 1222 passed, and it does just that.
Having access to all the rights that the Victim Rights Act provides, they can access safety measures for the home, they have access to therapy, they have access to counseling.
The new law takes effect in January. It adds protections for victims and their families, establishes conditions for probation, and requires additional reporting for courts on cases.
What's important is the conversation or the communication, let's say, between court systems. A perpetrator might be treated as a first offender many times if there's no record of prior acts of violence.
Denver sees 2,000 DV cases at the municipal level every single year. This week, council will vote to follow this new state law so they can continue to help survivors. Now, this new law also requires domestic violence suspects to relinquish any firearms while the case is pending. The number of domestic violence deaths in the state hit an all-time high last year. 86% were due to gunshot wounds. Kim.
Yeah, every time we hear about them, you think something else. There's got to be something else, kind of a stopgap, and this helps.
Yeah, absolutely. And we're talking about just in Denver alone, 2,000 cases. How many families are touched by that is probably even more.
Yeah, and just ripple effects.
Yep.
All right. Thank you, Kelly.